But good morning for those who've joined us. And myself and Phoebe are going to hopefully give you some insight, not actually how to go out and lose a tribunal, but rather how a tribunal may be lost. It's my hold for the title. I hope it's not misleading. It's certainly not intended to be negative, because really the reason we decided to do this talk is because quite recently Phoebe and I did a case in which we felt the result could have gone the other way, and in fact felt that it would have gone the other way had we not done certain things and had my solicitors not spotted certain things in advance. And it got us thinking that actually there are perhaps some rather subtle ways in which you can lose a tribunal before you're doing advocacy at the final stage. So today, this morning, what we're going to do is hopefully piece this together from inception of a claim through to the advocacy stage in a quite a swift run through that. There are obviously lots of topics we could deep dive into. We're not going to do that this morning. That's for another day. And give you some insight to some of the things that we consider not mistakes, but perhaps things that are missed, a bit more subtle. And I accept that employment litigation is uncertain. I also accept, and gosh, all of us on this seminar listening in know that it can be incredibly frustrating. It's perhaps one of the few venues, and I practice across a number of different courts, if that makes sense, but it's one of the few venues where you really can win unwinnable cases and lose cases that you really shouldn't lose, because sometimes it's just what happens on the day. That can still happen. And I accept all that. We accept all that in what we're telling you today. If we look at the various stages, the point is to say, well, I know you're only as good as the instructions you get. I know that a lot of the time that the good and bad has already happened in the way in which your clients or your claimants have dealt with or been dealt with. But actually, there are certain things that I don't think are utilized to their full extent in advance. And that's really the purpose today. I'll try and do it from the benefit, or for the perspective of both sides. We thought about this a little bit. You'll know that the majority of work that we do in the team is respondent oriented, but there's still a lot of claim work. And for obvious reasons, many claimants are unrepresented. So there's also that aspect that far more leeway than those that are represented. We'll clarify that in terms of what we mean when what's expected when someone's represented. The other purpose of today is to introduce you to Phoebe, the newest member of the team. And Phoebe's going to pick up issues of pleadings.
Thanks, Ben. Good morning, all. So we're going to begin in an obvious place with the start of the proceedings. So 81 and 83. Now, a key thing to be aware of is that, generally speaking, the employment tribunal system is very busy. Lots of practitioners on this call know that. And therefore, once a claim does get to a final hearing, it's very likely that the judge or panel, as it may be, has only had time or will only have time to read pleadings and the witness statements before the hearing progresses. So it's therefore really crucial that from the beginning of the litigation, the pleadings are correct and in a really good position, because they will ultimately be what is guiding the panel and the judge at the final hearing as to what the parties' positions are. So in terms of drafting, practitioners will be aware of this principle. But for those who aren't, you should generally be avoiding a narrative style. Don't want the full story in the pleadings. That's the role of the witness statement. And in the case of C&D, Herald Judge Tucker gave some really helpful guidance on this, distinguishing between claim forms and witness statements. And really, the claim form should be a brief statement of the relevant facts, along with the causes of action being relied upon. That is effectively telling the other side what they have done and what they haven't done, which is lawful. So it really is to distill the relevant factual matters to their essential or parts. So thinking of this in terms of claimants, particularly those who are unrepresented, can understandably like to include everything that's ever gone wrong, or everything that they don't like or feel uncomfortable with. But really need to think pragmatically about what are your strongest claims, and really want to avoid diluting those by employing a scattergun approach or throwing everything in and seeing what sticks. And Ben and I heard this anecdotally a few months ago, a judge in a tribunal directly telling a claimant that if they keep putting more and more in the mix, their best would simply get lost. We also see this with this disability discrimination, where really the claim is a reasonable adjustments, but it's being thrown in under several different headings. Again, that's not ideal and not particularly helpful. Thinking of it on the other side, for the respondents, general blanket denial of the tribunal wants to be telling the reader, who ultimately will be the judge or the panel, why the claims are denied. Because having read those pleadings on the first day of the hearing, they will know why you're saying the claimant is incorrect, which will mean going through cross-examination will be much more easily understood, and the judge or panel won't be having to figure out your position as the case progresses. So just moving to the next slide, continuing with pleadings. We also often see key elements of claims being omitted or missed in pleadings. So this is obviously something you want to avoid, but it's also something you should be directly calling out in your own. So as we've said, claimants, less is expected of them, and if they're represented, but if they are represented, you must be explaining the claim in full. And a fair amount of employment tribunal claims, particularly discrimination, there's a number of elements to that claim. And we often see for some reason, some elements are just simply not pleaded or not addressed at all. So an example of this is Section 15 claim in the Equality Act, discrimination arising from disability. This requires the less favorable treatment to be motivated by something arising out of a disability. A common example of this is being absent from work because you need to attend regular medical appointments. We see for some reason the something arising is frequently omitted for pleadings. And this is something that the respondents should be calling out and addressing in their response. Similarly, this cuts both ways, and claimants also want to be closing down the gaps or pleadings of the respondent. A key example of this is, again, in disability discrimination claims, where the employer's knowledge of the disability often is not dealt with, or it's not addressed from an own point, or there may be a simple blanket denial with not much more detail. We think claimants can do much more to exploit this and the employer's knowledge, and it should be very clear, or the claimant should make very clear why the employer knew, how they knew, and be giving that fuller detail, which I'm not sure about. And
yeah, well, I think apologies if we just had a message saying some of the sound is dipping, so I hope moving the speaker closer is assisted, and I hope you can still hear us okay. Yeah, it does cut both ways. I'd like to see in response pleadings calling out some of the gaps earlier. And Phoebe said before that one of the issues that we don't like, or one of the things that we see and tribunals don't like, I say it's the tribunals, are the blanket deniers. I appreciate that sometimes that's all you can do, because I've already accepted you're only as good as the instructions you get, and sometimes that's just a fail-safe. But if you're going to do that, you're going to want to supplement it thereafter. And if you don't, it just looks a little bit weak. So I'd like to see, from a respondent's perspective, the respondent calling out the gaps in the claim early doors. And the manner and style in which you do that is going to differ depending on whether you're responding to a litigant in person or not. But similarly, again, going back to the perspective of the claimant. I'd like to see the claimant calling out or preempting issues. So the knowledge point, a claimant saying this is why the respondent has knowledge, gives the response a need to ask or deal with more issues. So a great example of that, and I don't want to digress too much on what Phoebe and I have discussed a lot recently, which are pointless preliminary hearings on disability status or jurisdiction. But disability status is something that as counsel we're being pressed more on at case management. Is it going to be disputed, Mr. Williams? Why? The claimant's saying that there's occupational health reports here. And sometimes I'm being asked if I know what's in those reports. So invariably, I'm asking my solicitor to send those to me. But if you're responding to a claim and there are a number of occupational health involvements, or there's quite a long run up to the wicket, so to speak, and you've got a lot of absence, then really from your client, you're going to want to have a clearer idea about disability and moreover knowledge, because your best point is likely to be knowledge if you've got that, and also be aware of the danger of implied knowledge that is often misused. You'll see a lot of defenses on the basis that, well, Bob didn't know because the claimant had told Billy, but Billy didn't tell Bob. None of that matters. Once the employer is deemed to have knowledge, then that's the end of it. Whether individuals thereafter have been cascaded this information is not going to help that defense. So the pleadings are particularly helpful. I think with the one thing that I see missed, and I'm guilty of this as well, in perhaps not addressing it early enough, is objective justification. It should be clearly pleaded. It is often not, and even tribunal judges are pretty lackadaisical about it. They'll say, well, Mr. Williams, you pleaded objective justification. What is it? And I'll say, we'll let you know. And they'll say, oh, no, not a problem. And then ultimately it perhaps gets lost between the cracks. And actually, objective justification, which, always remember the test, a proportionate means of achieving the legitimate aim. Often that's your only defense, not just your best defense. Bearing in mind what I just said about the onerous requirements or way in which knowledge is deemed to work, implied knowledge in particular. It's not as frequently encountered in age discrimination, but don't forget it's a defense to that. And I've given you some examples there of how that might work. I know you know this when it comes to responding, but it's more this point that sometimes the objective justification is lost. And if it's lost at an early stage, it might mean you've lost that evidentiary. You might need to call a more subtle witness to deal with that. Might be a HR-led witness or otherwise. And I think that's really the message at this stage, albeit pleadings are extremely important, and albeit claimants will be forgiven for not saying everything and applying labels later, and albeit you'll not be prohibited from running an objective justification defense if you've not properly explained what it is. It's still, as a matter of law, something you can allow. The reality is, if you don't spot it sooner, the risk is you're not going to deal with it evidentially, and that's the concern. I've been in that situation where a judge has been saying, well, Mr. Williams, I can see what your objective justification defense is, and I can see what it was likely to be, but your witnesses aren't fully dealing with that. Is that something you want to reconsider? And actually I've parachuted in late witnesses to deal with that, which doesn't look good. It certainly means that you've got no chance of costs if you win at the end of it. So I think that's the message in terms of pleadings. I've put a bit more detail in terms of what a legitimate aim is, that you all will know what that is. But look, just saying it's a genuine business need is not enough. What is that genuine business need? Who, therefore, will be required to come and talk to that at the final hearing, even if it's a very discreet witness? And often it's very difficult for claimants to challenge that. It's all proposition-led. And tribunals will find that difficult to deal with, or claimants will equally find it difficult to gainsay what's being said. So from a tactical perspective, the earlier you spot this, the earlier you deal with it, the earlier you shut that down. That's your fail-safe if the evidence doesn't go quite as you want it to, even if you've got arguments about whether there has been discrimination in the first place. Don't forget the proportionality test. You don't just need that genuine business need, for example. It needs to be something that is thereafter proportionate. And again, I don't see it enough that that's been led by evidence from a witness. We move on to list of issues because this is a bane of my life, I have to say, and I know it will be for the hardened respondent lawyers, the frustration in the ever-changing and movable feast that are lists of issues. But I have seen a real trend towards not a slavish reliance on, because that would be wrong, but a move towards being rather strict on not deviating from the list of issues. So dealing with some of the principles, it's accepted that these are not pleadings. You'll all remember, because Daniel Barnett reminds us, but we all remember the cases then against Y from last year. And the President, Mr. Justice Eady, described the list of issues as a useful tool for case management, but equally said it is not something that you should stick to slavishly and relying on the Brent case from some years ago. So we accept that from the outset, that you are not completely beholden to those list of issues. But I think the message this morning is that if great care is taken, particularly where both sides are represented, then actually, whilst there's not slavish reliance, there is a more strict reliance on that list of issues. And I've been in many tribunals where the judges said to the claimant, this isn't on the list of issues. And the claimants look blankly because they don't know what that means sometimes. And they're thinking, well, I don't really know what that list of issues is. And I don't know what it actually means, because it's something that just happened at a case management or preliminary hearing in front of a judge that I couldn't see because I was on screen. And then they look blankly, but the judge is saying, well, you're introducing fresh matters. And they're not part of the issues that I'm here to deal with. And actually, that could have caused us some great problems had they been allowed to deviate. But I'm aiming to say, where things are carefully case managed, Judge, this is not on the list of issues. This is not something we're in a position to deal with. It is not something that we intended to deal with, and therefore the claimant is going off-piste. And by the way, that impacts their credibility. So the message is, with those principles, make sure that the list of issues is carefully determined. You're under a duty to work together. I've said this a lot to judges, acknowledging that duty recently. And judges love that acknowledging. They'll repeat it back. You know, the parties should work together. And I appreciate it's very difficult with the distrustful litigant in person, but you need to temper that approach and do your best. In terms of the list of issues, I'll come to Phoebe in a moment. When I was doing a bit more reading for today, I confess, I found a really helpful passage in a case called Gale and Sandwell. It's a 2011 case, 2011 IRLR 810. And it's a Court of Appeal decision. And Lord Justice Mummery, at paragraph 21, says this. And this is going to be a paragraph that's going to be in my skeleton arguments before long. It says that if the employment tribunals are firm and fair in their management of cases pre-hearing and in the conduct of the hearing, the EAT and this court feel should, wherever legally possible, back up their case management decisions and rulings. So when it comes to case management, when it comes to defining the list of issues, the more robust you are and careful you are in that, the more likely it is that there's going to be strict adherence to it, and thereafter the less likely it is that somebody's going to be able to complain about it.
Thank you. Yeah, I think Ben's covered the majority of this, but on the slide, there's just some general guidance for you in terms of the list of issues. And I think a key point to pull out is that this is not something the parties should be arguing over. It's not controversial document, which can often be can be seen in our case management hearings. It's mutual, and it should be something that you're working together over. And just another example of the tribunal that we were in, the claimant wishing to effectively add to the list of issues. Judge was very sharp on far too far down the line. The list of issues as it is the case that I will be deciding. I won't be going much on over that. The party that he continued to ask questions irrelevant to those issues, as the judge said, you're wasting our own time here. So we think a secondary point that comes out of this is that the timetable of the tribunal here is pretty strict, and judges wanting to stick to it as much as possible. You can't still be adding more days to the end of the tribunal to go to run, go to far from ideal. So at the final hearing, the questions really need to be focused on those list of issues. So we're now going to move to disclosure on some general rules. So disclosure should obviously be flowing properly from the properly pleaded case and the agreed list of issues. Therefore, another reason why those should be done correctly from the very beginning. It's a disclosure duty that is one that carries on throughout the hearing, the ongoing duty, and it's one of a reasonable search, relevant documents, being relevant to the issues which are or have been in your control. We saw the importance of the ongoing duty of disclosure quite recently, and Ben touched on it earlier, where a claimant brought a claim for unfair dismissal. They were dismissed primarily because of their lack of skill in customer service, and that was a key performance indicator or KPI, which should be familiar with. And the case had been through case management, it had been through the disclosure process, and yet close to the hearing, it was identified that actually very little, or if anything, in the bundle showed the importance of customer service to that individual role. And that then led to further disclosure fairly close to the hearings. Now, without that disclosure, the case would have been much harder to win. So therefore, whilst understandable that late disclosure can feel uncomfortable, it is absolutely necessary in some circumstances, and it's well worth running it through with counsel in a conference prior to the hearing, or you could be running the risky game. To add to that.
Yeah, I think that, it's an ongoing duty, and I don't think a tribunal escapes, certainly those that I'd been doing over the last few years, escapes a situation where there isn't late disclosure. There's always something that comes out, and even with best intentions, things can just crop up. Things can just arise in the course of evidence that, frankly, nobody's considered. So that ongoing duty is incredibly important. And of course, you then battle, particularly with the litigant in person, the distrustful litigant in person, saying, well, this is outrageous. Why didn't I have this sooner? And they'll think that something is amiss. They'll think that you're misbehaving. So you've got to be careful in the way you explain that late inclusion. You're waving a red rag to the bull if you just say, oh, by the way, here's something else, to maybe contextualize it in accordance with our ongoing duty. This has been discovered as a result of conference with counsel. Blame it on us, frankly. That's usually the best way. But contextualize why it's been found. And if there's an issue, invite them to raise it with the judge, because judges don't care, frankly. They seem really unperturbed by late disclosure. What they don't like is disclosure on day 6 of 7. But they don't mind the late inclusions to the bundle, because most of them really understand why that is so. You're going to have more of a problem in Bristol, of course, because they're much more strict with bundles. But whilst it's not a lack of strictness, it's really just pragmatism. We all appreciate that things can happen late. I do think Phoebe's right where that KPI case, she touched on disclosure and on that slide, I underlined relevance. Don't forget that proportionality and necessity are also key principles. They're often forgotten. Always go back to the CPR. Rule 31.6 deals with disclosure. Part 31 deals with disclosure and inspection documents. But it's not just that perhaps sometimes unclear argument of relevance. There's also necessity and proportionality, because there might be thousands of documents potentially relevant to a redundancy situation, for example, but we can't have all that in a bundle, and we can't always be disclosing all of that. And again, you're always battling that distrustful mindset of a claimant who thinks you as professional representatives are out to get them, are out to do the best for your client. They don't realize that the duty to the court is a higher duty. It's something that needs to be weighed into the balance and actually take precedence over your duty to your client in many ways. So don't forget that. I think with DSARs, we've been discussing this a lot because, again, you all know that they're utilized as a means of catching your respondent clients out. Maybe a number of claimants don't use them enough. And I'm going to talk in a moment about redactions and things that you might consider, but I wonder whether not enough is made of this useful tool, not enough is made by the respondent in responding to it. And I do get a lot of calls and have a lot of discussions with some of you about, we need to deal with things before disclosure, because there's potentially some documents that we don't think are particularly helpful. And sometimes there's a need to settle cases earlier, and you're just lucky that the respondent hasn't thought to do this. Then there are many cases where you would just get DSARs as a matter of course, particularly if they're represented, because you're advising them to do that. And the principles about confidentiality and redactions apply the same. You'd probably be a little bit more robust, particularly when it comes to redacting DSAR responses, because your supervisor is the information commissioner, not the tribunal, which is a little bit perhaps more personal when it comes to the litigation process. So I think I just wanted to wage caution on the importance of preserving evidence, and the core case is a really good case. I don't know how many of you have looked at it. Many of you will know what that's about. But what's really perhaps special about this case is the respondent lost. And then it went out for the remedy hearing. And in between, the claimant destroyed documentation that was relevant and extremely pertinent to remedy. And it caused the claim to be struck out, which was upheld at the EAT. So it's a case that really strikes at the importance of preserving documentation throughout. And I know many claimants think that things are withheld. And one of the ways to call that out is perhaps the use of the subject access requests, perhaps making more of the fact that sometimes the evidence that comes back as part of the DSAR response, where you client only has a month, is slightly different from what then happens as part of disclosure. And I don't think enough claimants make enough of that. And I don't think enough respondents are therefore called out about it. And that would give you, as their representatives, more to think about, more to deal with tactically, to stave off any suggestion that they're playing fast and loose with their disclosure obligations. Now, sometimes there's a perfectly acceptable response, which is really that the DSAR officer dealing with it at source has not performed the fullest of searches. But often there is something a little bit more shifty going on, and I do think that there's a reluctance to provide everything over. And the answer to that is really your clients need to be taking advice from you at a very early stage. We know that. We know they don't talk to it. So that's really important, and it's another reason to say to them, look, take our advice earlier, because if you've dismissed or are about to dismiss an employee and you've got a DSAR, that can have real implication potential on litigation that may or may not follow. It's a huge topic. That's why I'm only touching on it. I'm flirting with it today, but I do think that the confidentiality, I know it gives you some of you sleepless nights. It can be a tricky topic to navigate. And I don't think that tribunals are particularly good at dealing with it, actually. I've seen a lot of good, bad, and indifferent, more bad and indifferent ways in which they deal with redactions and confidential documentation. But I think there's more you can make of that at an earlier stage that can really tee up a claim if you're for a claimant, or really shut down a claim if you're for the respondent. Now, I think topics such as legal advice privilege, without prejudice privilege, are bread and butter. I think they are matters that you all know far better than I, actually, because you're dealing with it at source. Litigation privilege sometimes causes a little bit more difficulty, and don't forget that it is when litigation is commenced or where there is a real likelihood, not just a mere possibility of litigation. And I do think that is a movable feast for some. And that is just to be cognizant of the fact that you only get that protection where the dominant purpose of the communication is to give or obtain advice for litigation. And you'll be very cautious about the manner in which you deliver that to your clients, such that they need to be careful how they rely on it. I'm thinking in terms of ill health dismissals in particular, where this does tend to crop up, because it might be a much earlier stage where we can see what's going to happen somewhere down the line, or SRSR dismissals where you've got an impasse where the claimant doesn't want to play ball with a search for redeployment when they're plainly not able to do their job anymore. So you've got to be very careful and think about how you're going to justify that element of privilege. But I think people lose how easy it might be to see how this could impact the outcome. And if you're not careful in how you deal with litigation privilege, I dealt with many tribunals where we are looking at the employer saying to the individual, for all intents and purposes, we know you're not going to come back to your job, so what are we going to do about it? And that might be perfectly reasonable in the grand scheme of things, but it doesn't look good. And the claimant's going to say that it's predetermined. And it just makes it a bit more difficult for me at the end of the match, maybe to defend that for the final hearing. So I'm not sure that things are or enough is made of this. And just because things are marked confidential doesn't mean it is confidential. That is a classic error, because your clients just mark it on the assumption that nobody will read it. I've always remember the advice of my pupil master, as we used to call them, pupillage supervisor now. Always assume anything you write down is going to be read by a judge is a pretty good way to approach things. Of course, your clients don't do that. We as lawyers are particularly good at covering our backsides, aren't we? That's probably what we're best at. So we perhaps always assume that subconsciously. But clients don't. And that's going to be a matter of training and guidance for you to give them. But it also means if you're looking at that documentation for the purpose of a disclosure exercise, you've got to tread very careful. I don't think enough is made of specific disclosure. I don't think claimants know how to utilize it. And that's difficult to predict, I suppose. But specific disclosure, you get a lot, you do see requests. They tend to be a little bit left field. They tend to be asking for things that don't exist or never would exist. But I wonder whether respondents make it of such requests. I don't see hardly any requests for specific disclosure from respondents. Perhaps as counsel, we don't always see that as part of the build-up to litigation. But I'm thinking particularly in terms of diaries. well, not amazed, but it seems to be routine that I get to tribunal. I'm cross-examining a claimant, and lo and behold, I'm asking where they got this account from in their statement that didn't appear in their grievance, for example. And they say, well, it's from my diaries. And I say, well, where are those? Why aren't those in the bundle? Oh, I didn't know I had to produce that. Well, that, frankly, is something they ought to have known. But I wish it was something that was called out sooner, even if it's just a stock. And we're assuming you've got no diaries or recordings because you've not produced any. Please, can you confirm the same? And you might not get a response. But that would play out rather well for me in cross-examination if faced with that scenario. And what it does is taints the tribunal. They're just thinking what many of us think, that the claimant is mad. The claimant is just making this up as they go along or playing fast and loose. So I think it's really important. I know I'm speaking a lot. Let Phoebe speak in a moment. But redactions is another bane of my life because I know claimants will be frustrated that they just get reams of redacted documentation. Makes little sense. And I don't think tribunals deal with redactions well at all. And I think more could be made. And this is a really useful tool in terms of protecting your clients if you're a respondent or calling the respondent out if you're a claimant. Look at the case of Frewer in Google. The citation is 2022 EAT 34. And that's a really helpful guidance on how redactions ought properly to be approached. And I know that tribunals don't do this. Respondents just think they can do what they want with redactions and wait. And that's a dangerous game because if a claimant knows what they're doing and you're called out on it and you've redacted things you ought not to, then a lot could be made of it. But that points to what was Rule 50, now Rule 49, also worth reminding yourself of. And that's a case in which the tribunal said, look at the principle of open justice. That really should dictate. You're only redacting things that are necessary, things that are genuinely confidential. And I think if you look at that case, you get some helpful guidance on how you might approach it. And I just wonder whether respondents ought to head this off earlier. They ought to, sounds a bit of an oxymoron, but be transparent in your endeavors to not be transparent, if that makes sense. Because you want to say, there are reasons why we've redacted this. These are the reasons, and this is why we're doing it. And actually, there are means by which the tribunal can have private hearings to deal with redactions on an appropriate level. So not enough is made of redactions, in my view. And the way to approach them, that final bullet point, is really cautiously is the underlying message. But look at the Frewer case, the Google case. It's particularly helpful. Witnesses. Well, I'll hand over to you, Phoebe, because you've seen a lot of the way we've dealt with this. You've seen where it's perhaps gone a little bit wrong, or why witnesses are routinely very nervous, aren't they?
Yes. Obviously, as practitioners, we deal day in, day out with legal matters and the practicalities of tribunal proceedings. But a lot of witnesses have had no involvement with the law or any type of proceedings before. And even those that can present as cool and calm can be affected by the abnormality of the process. So we often do conferences with witnesses before the tribunal, just to get used to the language, being in the room with counsel, and all those tricky questions, or there's never any wrong questions. All of the witnesses can get those out. And whilst there are often common questions, but unique questions come out often all the time with witnesses, showing that they all have very different experiences of the tribunal process. And you really can't assume how they feel or the knowledge or experience that they have. So we really do encourage the use of conferencing beforehand. And then in terms of witness selection, I think there's an interested time and think what that's to Ben on that.
Yeah, witness selection is, I jumped the gun there, Phoebe, apologies. I I still see, I know those experienced lawyers on this seminar know not to call investigators when it comes to unfair dismissal, but I still see that's a lot. Sometimes it's necessary, particularly if there's a parallel discrimination claim. The biggest issue is unavailable witnesses. I'm routinely told, well, look, we can't rely on this witness. That's a concern I've got because they left under a cloud. And I'll say, well, consider the witness order. And look, it's a hard no. I think there's perhaps a view taken that people appearing under witness orders are not going to make good witnesses. And that's not always so. My experience is that tribunals don't really care a great deal. They know that an individual is there under an order, but equally they understand how time moves on, particularly in 2025 as we sit, where you're waiting a couple of years to hear a case or have a case heard before the tribunal. They know that things can happen. So don't be afraid to consider that, but equally, don't be afraid to call a witness to deal with those evidentiary gaps. It's perfectly acceptable in the tribunal process. And if you've got good HR representatives who, for all intents and purposes, are akin to your instructing solicitors, then rely on those. They can get up to speed. They can close the gaps. They can do their own investigation, if you will, or their own sweep of what's happened and talk with authority that might work. I appreciate there are difficulties when it comes to an absent witness who is the protagonist in an alleged discrimination. But that does present an evidential problem. But again, I suppose my answer to that would be the advice you're giving your client to make sure they run robust contemporaneous investigations. Had one recently. I think next week our case, it feeds into this, that what the employer did, even after somebody resigned and thereafter raised a grievance, is run a very good and robust post-termination grievance process. That is my fail-safe in this case. That's something that should see us through. So it's tricky, but I absolutely echo Phoebe's point. I'm bound to say that on behalf of the team, aren't I? You need us. You need the pre-hearing conferences, but they've been really fruitful of late in picking up on things that perhaps would have been missed otherwise, particularly concerns that witnesses have that I wouldn't know about if we hadn't. I think that's pretty much everything we wanted to say, isn't it?
I think so, yeah. And I think we've overrun a little, so apologies for that. If anyone has any questions, feel free to contact Ben or I, our parks, or through the feedback form. We hope you've taken something for today, and hopefully be in touch.